Muri Zimbabwe ave masikati akanaka kusangana kwatiri kuita nhasi uno musi wechina 19 February 2026 kusangana pano paMbire TV patinokupai nhau dzezviri kuitika munyika yedu yeZimbabwe. Nhasi mangwanani panga paine dhibheti rakaomarara zvikuru, dhibheti riri maererano nenyaya yekuda kuvandudzwa kwebumbiro remutemo wenyika yeZimbabwe. VaJonathan Moyo ndevamwe vari kunzi vari kushanda nebato reZANU-PF vakashandidzana navaziyambi-ziyambi pakuunza bumbiro remutemo wenyika idzva. Bumbiro pari zvino riri kutaurwa kunzi rava pasiteji yekuva pamaconsultations, veruzhinji vachibvunzurudzwa kuti vari kuona sei danho rava kutorwa nebato reZANU-PF. Naizvozvo vaJonathan Moyo vanga vari padhibheti pamwe chete negweta rinonzi Justice Mavedzenge. Justice Mavedzenge avo vava nemubvunzo kuna vaJonathan Moyo kuti chachinja chii, nekuti mugore ra2018 vaJonathan Moyo kuburikidza nemubhuku ravo Excel Gate vakapomedzera vaMunangagwa mhosva yekubasa rudzodze gore ra2018 pamwe chete nekuvapomedzera mhosva dzeutsinye kuita zvechipfambi pamwe chete nemoney laundering, mashoko anova akataurwa navaJonathan Moyo zvaita kuti vange vachibvunzwa naJustice kuti sei zvachinja papi nhasi mava kusapota vaEmmerson Mnangagwa wavaitaura kuti haana kumira zvakanaka. Tichakupuleyerai dhibhete raitwa pakati pevarume ava apo pari kuratidza kuti vaJonathan Moyo vazoguma vava kupupa furo maererano nemibvunzo yavanga vava kusangana nayo. Izvo zvataurwa naJustice Mavedzenge kuti zvese zvavari kuita hazvienderane nepfungwa dzavaive nadzo kumashure uku, kureva kuti pane zvakaitika kana kuti vaJonathan Moyo vanogona kunge vakabhadharwa mari. Ndichatanga kupuleya response kana kuti presentation yavaJonathan Moyo maererano nevandudziko irida kuitika pabumbiro remutemo. Ndozopuleya presentation yaJustice Mavedzenge. Mova nekuenzanisa kana kuti nekusefa mazwi kuti ndiani ari kutaura zvine musoro.
The 10 minutes that you have afforded. But I was making a point, a preliminary point, that by their very nature, constitutional issues are not rocket science. They are everyone's issue. And that's why in our country, which perhaps because people are too much into textbooks, they think that constitutional issues are an exclusive preserve for lawyers. And yet, in fact, these issues are important precisely because they are everyone's issues in the literal sense. That's why a good constitution or a good constitution moment such as this one is the one that has something for everyone. And when that is clear, that's when the lawyers come to draft, but drafting what is not coming from their heads, but is coming from the aspirations of the people, in this case, not only through such conversations, which started on Monday, or more technically on Tuesday, the counting, 90 days. Otherwise, I would like to thank you for this opportunity. I want to start by pointing out that a presentation to a discussion of this nature must, in my view, begin by stating what the essential and critical issue is, which happily in this case, it is common cause that it is about the Constitution of Zimbabwe Amendment number 3 bill approved by Cabinet last week and gazetted by Parliament this week. As one among many others who have been intimately involved in constitutional reviews over the last 26 years, notably during the people-driven exercise that produced the 2000 draft constitution prepared by the Constitutional Commission and the compromise produced in 1987. We should bear in mind as we debate this, that when this system was introduced at that time, it was in anticipation of the establishment of a one-party state. The 1987 amendment was enacted with explicitly intentions of consequences that had arisen as a direct result of the introduction of the executive presidency in 1987. The 2000 constitution, the draft constitution that is, sought to address this issue under a hybrid compromise that sought to bring back the office of the Prime Minister, drawn from the party in Parliament commanding the majority, as the head of government, while retaining the President as the head of state, but with reduced executive powers. Unlike the 2000 draft constitution, at least from the point of government, since that process was a government process, the 2013 constitution did not even attempt to address the issues related or rooted in the 1987 amendment. Instead, it retained the presidency, the executive presidency, created in 1987 in anticipation of a one-party state, but at this time, retaining it under a constitutional framework for a multi-party democracy enshrined in Section 3.2a of our Constitution, and which framework is a running thread throughout the rest of the Constitution. The Constitution enacted in 2013 presupposes the existence of a multi-party democracy. But the executive presidency, which was inherited without even a single amendment in 2013, was, and this is not, this is an open secret, but it is an objective structural question. It was enacted anticipating that by 1990 or after the 1990 general election, there would be a one-party state. But it didn't happen. The fact that this was retained in 2013 by a constitution whose framework anticipates a multi-party democracy naturally led to a self-evident structural breakdown, which has spoken for itself since 1990, exemplified by the scourge of disputed presidential elections and the toxicity associated with it. That's the first mischief that the amendment or the bill is addressing. The second mischief is that over the years, but this is a colonial or pre-colonial problem of all countries that were under colonialism, such as Zimbabwe, which adopted a shorter 4 or 5 year term of office for the elective institutions, namely the executive and the legislature. The adoption of these short term of office provisions or structures or election cycles has been problematic in that the period is too short and tends to perpetuate permanent election modes, with the next election starting immediately after the last. breeding populism over service delivery, exacerbating societal divisions, ethnic divisions, and leading to bureaucratic inefficiency. Data from at least the 16 African countries in the Commonwealth shows without doubt that shorter terms of office adopted in post-colonial constitutions, ostensibly to promote democracy and accountability, often have tended to incentivize divisive rhetoric, divisive politics, ethnic mobilization, and critically, the neglect of long-term infrastructural development within fragile context, which have weak institutions and which perpetuate instability, such that the traditional enemies or grievances of the people that fueled the nationalist struggle, hunger, poverty, disease, ignorance, have not been addressed. They are difficult, if not impossible, to address within shorter election cycles. Therefore, in my view, by amending sections 92, 95, subsection 2B, 143, subsection 1, and 158, subsection 1 of the Constitution, the bill addresses these two mysteries. And it does so not by altering the structure of government or its fundamental institutions, but principally or in the main, by transforming the system of electing the president and the period or the duration of the national election cycle, which affects only two branches of government. Those people who talk about power, whether it's executive power in Section 88, derived from the people, or the legislative authority derived from the people, and saying therefore you must have direct elections, must confront the reality that judicial power is also derived from the people, but the people do not directly elect the judges. But in any event, the point is that this reform package, constitutional reform package, whose core amendments are those that I've outlined, directly tackles these two situations that I outlined just a little while ago. In the circumstances, the reforms in the bill are neither cosmetic nor partisan. They are historic, strategic, forward-looking, and deeply patriotic. In particular, the reforms in the bill seek to strengthen Zimbabwe's hybrid electoral system, which has developed to be one of the best, the hybrid election system that is, in order to align it first and foremost with Zimbabwe's constitutional realities going back to at least 1987, as I pointed out, and to also, in the second instance, align it with proven best practices in the SADC region and in the Commonwealth, which Zimbabwe seeks to rejoin. All told, the reforms position Zimbabwe for institutional maturity and enduring stability. And in this regard, quickly, but hopefully without losing much of the content, I would like to highlight 5 or so underlying principles that are necessary to understand if we appreciate what the foundational question is in terms of the mystery being addressed and what the core amendment seek to do about that foundational question. So quickly, 5 things. Firstly, and at the heart of the gazetted amendment lies a foundational constitutional principle under section 117, subsection 2A of the Constitution. The current the principle is that the current 10th Parliament possesses unassailable authority to amend the Constitution in accordance with Section 328. It is bound neither by the 7th Parliament that gave birth to this Constitution, nor by the 8th and 9th Parliaments that enacted later amendments to it in 2017 and 2021, respectively. This legislative independence of the 10th Parliament is not a technicality. It is the living expression of the democratic doctrine that one legislator cannot bind its successors. It is called the anti-entrenchment rule. No parliament may forever shackle those parliaments which come after it. Each new parliament is sovereign and retains the unfettered right to repeal, amend, or replace the laws of its predecessors. To deny the 10th Parliament this principle would, in my considered view, be a dangerous surrender to the tyranny of temporal majorities, allowing yesterday's choices to imprison today's realities or will. Permanent entrenchment of laws freezes progress and suffocates hope. The 10th Parliament, therefore, stands not merely authorized, but solemnly duty-bound to shape Zimbabwe's constitutional destiny with courage, clarity, and unyielding authoritative legitimacy. That's where legitimacy comes from, not from the whims and caprices of players in the political process. Secondly, the constitutional prescribed process for amending the Constitution is enshrined in Section 328. This section establishes a rigorous, multi-layered procedure designed to prevent hasty or self-serving alterations or amendments of the Constitution, while empowering Parliament to refine governance in response to evolving national situations and aspirations. This is why any constitutional bill must be published with precise terms, allowing at least 90 days for public consultation in terms of Section 328(4), consultation and scrutiny, to enable the broad societal input. The bill must then secure the affirmative votes of at least 2/3 of the membership of both the National Assembly and the Senate at its final reading, a threshold that demands cross-partisan consensus. This way, the amendment process honors the foundational principle that the supreme law of the land derives its authority from the will of the people expressed through their parliament. This is in the Constitution. Thirdly, and critically, Section 328, subsection 6, reserves the ultimate democratic veto, namely the referendum or national referendum, but it does so only for the most sacred and entrenched elements of the constitutional order, namely any constitution bill seeking to amend provisions within Chapter 4, the Declaration of Rights, or Chapter 16 concerning agricultural land. Section 328, subsection 9, extends this similar protection to Section 328 itself, deeming it an integral part of the Declaration of Rights in Chapter 4. It is only and only in these three exceptional cases where a constitution bill having secured 2/3 approval in Parliament must be submitted to a national referendum within 3 months, in which approval by a majority of participating voters is indispensable. All told, the referendum in constitution making in Zimbabwe is not a matter of the wills and caprices of people who demand it or use it as a political weapon. It is strictly a matter of law, not conjecture or an expression of the desires and wishes of political players. who invoke it usually for conflict mongering. Otherwise, for all other provisions that are in the Constitution, outside Chapter 4, Chapter 16, and outside Section 328, such as those that are affected or term limit provision, necessarily triggers a referendum. This is false in my respectful opinion. Recall that the Constitution mandates referendums only for amendments to chapters 4 and 16 and section 3 to 8. There is not even one term limit provision that falls under these parts of the Constitution. And this is not to say anything about the bill, but to say something about term limit provisions. There are 15 term limit provisions in the Constitution, and none of them is touched by this bill. So, and in fact, conveniently, these were speculated or shared yesterday by the Attorney General. And there is, however, an exception under Section 3287, where or if an incumbent is to benefit from an amendment to a term limit provision, not any other provision, but a term limit provision, then Section 3287 is triggered and a referendum might be required if the intention is to benefit an incumbent who holds an office which is subject to which has term limit provisions as defined by the Constitution. But to be clear, Section 328, subsection 7, comes into play or imposes a referendum only if an amendment is to a term limit provision. And we should underline that, to a term limit provision and not to any other provision. And if the amendment extends an incumbent's tenure for someone who held the office before its enactment. Section 328, subsection 7, provides that notwithstanding any other provision of this section, an amendment to a term limit provision, the effect of which is to extend the length of time that a person may hold with time, an example being Section 95, subsection 2B, and Section 143, subsection 1, or even Section 158, subsection 1. But we have to be clear. The operative phrase in Section 3287 is that the affected amendments must be a term limit provision, not any other. And subsection 1 of Section 328 provides that a term limit provision means a provision of this Constitution which limits, the provision must limit, which limits the length of time that a person may hold or occupy office. If the provision talks about time, but does not limit, does not put a cap on the time, then that provision is not a term limit provision. For a clause or section of the Constitution to qualify as a term limit provision, it must expressly and unambiguously put a limit or a cap on the time that a person may hold or occupy the office. If there is no limit or cap in that provision being looked at, then that clause or section is not a term limit provision as contemplated in Section 3281. Using dictionary definitions of the words term and period, the Constitutional Court in the landmark case of Max Mpungu versus Minister of Justice, Legal and Parliamentary Affairs and 6 others held that, I quote, a term is defined as a fixed or limited period for which something, for example, office, imprisonment or investment lasts or is intended to last, while a period is defined to mean a particular length or portion of time. In other words, in the language of section 143, subsection 1, a duration of time of parliament is a period. In light of these definitions, a term is a period. This is in the Mupungu judgment. In the light of these definitions, a term is a period of time which is ordinarily measured by using a particular unit of time and which has a known beginning and a determinable end. The operative word is that unlike a period or a duration which might be subject to contingencies such as age or election cycle, which can't be fixed exactly unless we are in jurisdictions like in the United States, where it is known that every 2 years, the first week of November has national elections, congressional elections, for example. If an election cycle is provided, subject to, and so forth, is contingencies, then it is a duration which is not, or which does not have a known beginning and a determinable end. Therefore, a term limit in this understanding is a cap on that known beginning, a beginning which is known and an end which is determinable. As such, term limit provisions place a measurable lid on tenure with unyielding limits like non-renewable term, renewable once, not more than 2 terms, or total such as up to a maximum of 2 terms, or renewable once subject to competence and performance, and so forth. All term limit provisions in the Constitution, the 15, guarantee no endless or contingent extensions. They guarantee specific ends, not the kinds that are endless, open, or contingent. Fifthly and lastly, the following stands to reason from the foregoing. 55 subsection 2b and 143 subsection 1 are election cycle provisions, and they are critical for that purpose, and they are found in all governments, systems governments, democratic, monarch, or communist, and so forth. They all define the period between the election of one president or head of executive and the next, or the legislature. It is crucial, not just as a matter of public law, but as a matter of civics 101, to know what is the election cycle of the government, the elective part of the government. It's an important civics lesson. And that's why in our case, we didn't introduce these sections, 95 subsection 2b and 143 subsection 1 in 2013. We introduced them in 1980. We had them throughout the 37 Mugabe years. Why? Because for sections 95 subsection 2b and 143 subsection 1 are election cycle provisions, not term limit provisions, and they do not belong to the protected category of term limit provisions that require a referendum. 5. There is no implication arising from section 3287 because that section only affects term limit provisions and not non-term limit provisions which are amended in the bill. 6. The bill only lengthens the election cycle from 5 to 7 years to break the toxicity of a permanent election mode in between elections. It's a Sabbath solution which everyone in Zimbabwe has had, from the churches who came up with the Sabbath proposal in 2021, to NTA, who have their own Sabbath proposal, and it is in the body politic. The Sabbath proposal is in the psyche of any and everyone who has bothered to reflect on this proposal. It is not conjured up in thin or from thin air. And it is important to say that as far as election cycles are concerned, the minimum as we speak is 10 years. 4 or 5 years is the medium. But there's a lot of literature, and at some appropriate time, we will share this literature, which shows that many countries, African countries, which now are seriously grappling with the infrastructural policies and projects, which rely on presidential systems where there's the divisive direct elections and so forth, are reviewing this. We are not the only ones who are reviewing this. And as recent as in last September, Guinea made this transition to 7 years. So the bill number 7, the bill is not about the president. It is about the presidency and about parliament as institutions, not members of parliament, not the president. And for the avoidance of doubt, in order to understand that section 95(2)(b) is not a term limit provision affecting the president. Consider this scenario. A presidential successor under section 101, following, say, a resignation of the incumbent or removal or a death of an incumbent after they've served, say, for 2 years. When that happens, the successor assumes only the remaining period of the term of the election cycle. If the election cycle is 5 years and the incumbent goes after 2 years, the successor just serves for 3 years. And this ensures continuity of the cycle without restarting the clock or a fresh term. This alone should settle the question that the period of 5 years does not belong to the office holder. It belongs to the office and can be held by many or several office holders. The same scenario is true in connection with a parliamentary by-election following a vacancy. In line with parliamentary term of office in section 143(1), they fill the by-elections, they fill only the remaining election cycle time. One does not win a by-election to demand a full 5-year term. They win a by-election to serve a term started by the person who caused a vacancy for whatever reason but couldn't continue. I say again, if we are really serious, this should settle the question, because it's so clear that in both the case of the presidency, as described in section 95(2)(b), and in the case of parliament, as described in 143, we are talking about a term of office, not a term of officer. The terms of officers are described elsewhere. For the president in section 91, subsection 2, for parliament in sections 121, 125, and 129. For parliament, you don't find any term limit whatsoever. For president, you do, and it is in section 91, subsection 2. Parliamentary election of the president will therefore, in my view, as proposed in the amendment or in the bill, shield the office of the president from those ills which I summarized in terms of the two-fold elements, which cause polarization, which paralyze policy making, breed endless disputes, and these have bedeviled our country with respect to presidential elections since the advent of those elections in 1990. and the indirect election will promote and strengthen national unity to give everyone and all communities, and I emphasize all communities, a voice in national governance through their representatives in parliament, in line with the section 3, subsection 2A of our constitution, which provides that the principles of good governance which bind the state and all institutions and agencies of government at every level include a multi-party democratic political system, which right now is at conflict, is not there. You can't have a multi-party democratic system when everything else speaks to it, but the most important office in the land doesn't do so. It creates a completely different process and structure. The direct election of the president is in direct conflict with the founding value and principle of good governance enshrined in section 3 of the Constitution. It is my considered view, therefore, and non-Hlanhla, as I conclude, that President Mugabe and his cabinet on this score of the bill deserve unqualified national commendation for coming up with the bill. It has taken quite some boldness. We didn't have it in 2013. People just made a compromise and took lock, stock, and barrel a self-evidently unworkable structure which has caused the government to have a constitutional commission in 2000. So on account of this progressive bill, in my opinion, we have to commend the government for coming up with it. In advancing the bold initiative, they've signaled a historic transformation that honorably reconciles Zimbabwe's troubled past with a promising future of real developmental progress beyond 2030. They are affected because it is the future players who are undoubtedly going to benefit from this and who will have the opportunity to improve it and make it even better. I thank you.
Well, thank you so much, Professor Jonathan Moyo. And guys, if you're just joining us here on this morning on Asake, welcome to the show. We are dissecting the legality of extending presidential terms. And you've just heard Professor Jonathan Moyo's arguments. And now I'll give the floor to Dr. Justice Mavedzenge to give his arguments as well. Dr. Justice, please do take as much time as you would wish. Over to you.
Thanks, Nonhlanhla. I hope you can hear me.
Yes, you're clear. Please do go ahead.
Fantastic. Good morning, good afternoon, good evening to your listeners, to Zimbabweans everywhere. I think some few preliminary points to just make. And I did not want to make these points. They were not in my original presentation layout, but because this is a debate, so I have to respond to what Professor Jonathan Moyo said. The first thing I want to sort of clarify is that it is true that these debates are not a preserve for lawyers. But we must agree out of decency as a society that people without legal expertise should not be driving something as serious as a constitutional amendment. It is like asking a lab technician or a nurse to perform a heart surgery. It's quite dangerous. And frank, part of the challenge that we have as a country is we have a whole Minister of Justice has never practiced law anyway. And I know that we are not the only country in such a situation, but that doesn't make it normal. So I just wanted to clarify that. Second point is I'm surprised that Professor Moyo, who once described President Mnangagwa as a leader whose core values are cruelty, sex, and money, And today he now tells us that such a person should stay longer in office beyond his term, reportedly to address electoral toxicity. In 2018, recently, Professor Moyo wrote a book which I have here with me titled Excelgate: How Zimbabwe's 2018 presidential election was stolen, by Jonathan N. Moyo. In this book, which I have read and used quite extensively in my scholarship, he exposes how President Mnangagwa stole the 2018 election. But also he says something about the President Mnangagwa's involvement in stealing previous elections. But today he says the same person is driving reforms to address electoral toxicity. One wonders what has really happened with the good professor, because his position is not in sync with what he has told us before. I am saying this not to attack Professor Moyo, but because he has invited us to congratulate, to embrace, to be excited about this raft of constitutional amendment proposals, because they are meant to address electoral toxicity. And it doesn't make sense unless Professor Moyo is able to then explain to us what has happened since he wrote his book in 2018 and other publications before. The other thing that I want to clarify is that I am participating in this debate because I have a precise objective: to expose this planned constitutional coup, which is packaged as a constitutional amendment. Before doing so, I must point out that democratic space in Zimbabwe has virtually been closed down by President Mnangagwa's administration. We are therefore having this debate in a context where, one, those who criticize President Mnangagwa and his policies are subjected to threats of arrests, detention, torture, and even extrajudicial killings. A good example is the vicious threats that journalist Blessed Mhlanga has been facing for the past 2 days just for speaking out against government's repressive policies when he attended the Geneva summit. The second point which illustrates the kind of an environment in which we are having this debate is that vigilante groups, including one called Zimbabwe Anti-Presidential Criticism, led by Mr. Andrew Pasinawako, have been formed and are allowed to continue harassing those who critique the president and his policies. Another example is the recent bombing of the SAPES trust offices in October 2025, after a group of Zimbabwean civic and political leaders decided to hold a press conference to speak out against the now proposed constitutional amendments. And up to date, there is no progress in investigating the massive destruction of that property. The Zimbabweans have established platforms to peacefully mobilize themselves against this constitutional amendment bill. So far, these platforms include the Defend the Constitution platform, DCP, and Constitutional Defense Forum (CDF). Members of the organized civil society in Zimbabwe. So this is the context, and in this context, it is extremely risky to be engaging in this debate. And the risk is even bigger for those that are peacefully organized in the masses to speak out against this proposed constitutional coup. But nevertheless, we cannot afford the silence, especially in the face of what I personally regard as the biggest planned constitutional coup in the history of this continent. I'm happy to demonstrate with examples why I regard this as the biggest planned constitutional haste in the history of the African continent. But now let me deal with legal issues. The proposed constitution, the proposal to extend, first let's appreciate that there are a raft of propositions that are contained in this constitutional bill. It is my respectful view that a lot of those other proposed amendments are just an attempt to divert our attention from the real thing. The real thing is that The bill seeks to extend the president's term of office without holding a referendum. And this proposal is both legally and politically problematic. And I will demonstrate why. President Mnangagwa and the proponents of this bill are seeking to amend the constitution without following a due process. And we are once again witnessing attempts to mutilate the national constitution in order to manage ZANU-PF's internal succession crisis. I need to emphasize that particular point because it responds to the kind of propaganda that we have been exposed to up until now. Is what is the purpose behind this constitutional amendment? The purpose is to manage ZANU-PF's internal succession crisis. So our national constitution is being mutilated, just as we saw how the constitutional institutions were subverted under President Mugabe in order to deal again with the internal succession battle. And that led to the 2017 military coup. And I think it is important for Zimbabweans to keep that in the back of their minds, that the real purpose behind this, the real purpose behind this planned constitutional coup is to simply manage the internal ZANU-PF succession processes. Section 328, subsection 7 of the Constitution lays down a very clear framework for deciding whether an amendment to the Constitution should be done after a referendum or not. And the framework is this. If an amendment seeks to A, change a term limit provision, and has the effect of extending the length of time that a person may hold a position, then the amendment must be subjected to a national referendum. It cannot benefit the incumbent. The bill presented before us seeks to amend Section 95, subsection 2B of the Constitution by increasing the term of office for the president from 5 to 7 years. This is not my interpretation. It's what is written in the bill. To increase the term of office for the president from 5 to 7 years. And to allow the current president to continue in office beyond 2028 until 2030. This is what's in the bill. Then the question is Section 95.2, which is expressly targeted in the bill, is Section 95.2 a term limit provision? The short answer is yes. How do we know that it is a term limit provision? I will give you four reasons here that are very clear, some of which have been, in my view, distorted by attaching their own definitions to things. We need to quote the exact provisions of the Constitution. So Section 3281 says, open quote, a term limit provision is a provision of this Constitution which limits the length of time that a person may hold or occupy office. At this point, it is critical to clarify that a term limit provision is not about the number of times that a person may hold office necessarily, but the length of time that a person may occupy the office. Again, go back to Section 328. It's a provision of this Constitution which limits the length of time that a person may hold or occupy a public office. Section 95 2B defines the president can occupy that office. It sets the term at 5 years. I don't know why there's confusion about this. But let's move out of the constitutional text a little bit. If you ask any Zimbabwean, any village, in any street, if you ask them this question, when are elections in Zimbabwe due? They will tell you that elections in Zimbabwe are due every 5 years. So why do we hold elections every 5 years? because the term of office for the president is limited by section 95 to 5 years. We do not hold elections every 5 years because of section 91 because there is nothing in section 91 which says elections are due every 5 years. Let's read it together. Let's go to 91 because we must cite these provisions as they are so that we avoid confusion. Section 91 says, the title is Qualifications for Election as President and Vice President. Mind you, the title of that section tells you what it is about. It is about qualifications. But let's go into its substance. Subsection 2, it says, open quote, a person is disqualified for election as president or vice president if he or she has already held, open quote, a person is disqualified for election as president if he or she has already held office as president under this constitution for 2 terms, whether continuous or not. And for the purposes of this subsection, 3 or more years service is deemed to be a full term. Where does it say 5 years in that provision? There's not. It doesn't define the full term of the president. I will later show you what the purpose of 91 2B is. But for at this particular point, I just want to deal with this propaganda that says the term limit, the only term limit provision for the office of the president is section 91. If that was correct, and if someone says, why do we hold elections every 5 years? The answer is not in section 91. The answer is in section 95. So that already tells you that section 95 is the term limit provision. Now, it is for these reasons that the Constitutional Court in Max Mopungu, U.S. Minister of Justice, has already identified section 95 as a term limit provision. It pages 50 and 51 of the judgment. But let me talk a little bit about section 91, because that is where a lot of propaganda is circling around. In an attempt, you see, when people are planning a coup, they first deploy propaganda precisely to mislead and confuse people. We have seen this in Zimbabwe. Whenever electoral coups have been planned, the first attempt was to criminalize opposition. The first attempt was to mislead Zimbabweans into believing that the opposition is some kind of a creature that should never be allowed to take over power. Right. Fast forward 2017, when a coup was being planned, we were told that the purpose of this whole operation is to remove criminals around the president. The same tactics are being deployed here to say, look, the real term limit provision is section 91. So I've already told you that the real term limit provision is 95. And I'm not alone on that. The Constitutional Court is with me because there's a decision which says 95 2B is the term limit provision. But let me show you what 91.2 is about. The argument of those that are sort of lobbying for this constitutional coup is that section 91.2 is the term limit provision, while section 95.2 is not a term limit provision. And therefore, as long as the amendment is not targeting section 91.2, it does not need a referendum. The title for section 91.2, as I said, is Qualifications for Election as President. That particular provision goes on to say a person is disqualified for election as president if he or she has already served as president for 2 terms. 2 terms of what? You can only answer that question if you go to 95, which is the matter of presidential term limits. 91.2 then goes on to say to define what makes up a single term. So of these two terms, a single term is 3 years and above. So what basically we have here is a scenario where section 91(2) is explaining and expanding limits that is defined in section 95. So section 95 is the cathedral for presidential term limits in Zimbabwe. It is the primary provision that limits the term of office. And it does not need, in Professor Moyo's language in the past, it does not need a rocket scientist to know that, because we have elections every 5 years. The president will not go beyond 5 years. If actually you go to the other judgment of the Constitutional Court, Jelas Mawarire, versus the president of Zimbabwe, I think versus Robert Mugabe. The Constitutional Court has already indicated again that the term of office is limited to 5 years. It is limited to 5 years. So you can't create any fiction around that in light of existing jurisprudence in the country, but also practice. Yesterday, it's true what Professor Jonathan Moyo said. Yesterday, the Attorney General's office published what I consider to be a mischievous and misleading flyer, which says the only term limit provision for the president is section 95. You see, I can understand when persons without basic legal knowledge fail to make a connection between section 912 and section 995. But I struggle to understand how a whole Attorney General's office can miss this. It has left me with two questions, and I'm sure those are the questions that other Zimbabweans would also have. Is the Attorney General afraid of telling the president the truth that the term limit provision is primarily section 95(2) as per the Constitutional Court's decision? Or is the Attorney General complicit in these sinister plans to subvert the Constitution? Now, let me jump to the second last part of my presentation. A lot has been said about this decision. It marks Mapungu versus Minister of Justice. Part of what has been said is to mislead people who actually are the owners of this constitution. The owners of this constitution is not ZANU-PF, it's not me, it's not any of the politicians. So one of the arguments that I have heard against this decision is that, what the court said in Max Mupungu is obiter and is not binding. Okay, let's break this down for purposes of our colleagues who may not know what obiter dicta is. Obiter dicta is a Latin term which refers to comments or observations that are included in a judge's ruling. And those comments are not essential to the decision. That's number one. They are not essential to the decision. Number two, and as a result, they are not legally binding on other courts. In other words, obiter, friends and colleagues, simply means a suggestion. The court was just making a suggestion or was just making a passing comment. Somehow,
Zimbabwe ndiyo presentation ya Justice Mavedzenge avo vanga vachidibeta mangwanani anasi na Professor Jonathan Moyo muzvinafundo avo vari kurarama vari kunyika yeKenya. Asi panapa taona Justice Mavedzenge vachibvunza vaJonathan Moyo kuti chachinja chii chakonzera kuti vange vachisapota vaEmerson Mnangagwa vavakamboti kumashure uku vakabiridzira sarudzo uyezve kuti vane hutsinye uyezve vanoita zveupombwe pamwe chete nemamwe mabasa akashata munyika yeZimbabwe. Chii chakonzera kuti vange vachitsigira kuvandudzwa kwebumbiro remutemo? Chii change chakonzera kuti vaJonathan Moyo vati vaEmerson vanaka nhasi uno? Ndo mubvunzo uri mundangariro nemupfungwa dzevanhu vakawanda vemuZimbabwe. Ndo debate ranga riripo muri yeZimbabwe. Tinokutendai nekutsigira kwamunoita Mbire TV. Ngatisangane zvekare mudzimwe nhaurwa dzatichazenge chikupakurirai panapa. Munguva pfupi tiri kuuya nenyaya yeConstitutional Defenders Forum, memba yavo yakabatwa nezuro, yakabhadhakutwa ikakuvadzwa. Pane update yatichazenge tichikupai munguva pfupi inotevera iyo. Asi panguva ino hatinoti musare zvenyu zvakanaka.